Hear ye, the Supreme Court of the State of Idaho is now in session pursuant to law. Please be seated.
Thank you. At this time, we're on record in Verity versus USA Today et al. Matters set for oral argument. On behalf of the appellant, Deborah Kristensen will argue. And Kirsty Kennedy will appear. On behalf of the respondent, Ronald Shepard will argue, and Peter Mommer will appear only. Matter is set for oral argument. Are there any preliminary issues?
No, Your Honor.
Very well, you may proceed.
Thank you, Your Honor. May it please the court. Deb Kristensen. I represent the 5 media defendants who are the appellants in this case. We have been sued by Mr. Verity under 3 different claims: defamation, false light, invasion of privacy, and intentional infliction of emotional distress. As the court is probably well aware by now after reviewing the extensive briefing, this is a case about whether and under what circumstances members of the media may be held liable for truthfully publishing matters on public concern. Up until this time, in this case in particular, the journalists here in Idaho believe that if they truthfully publish matters, particularly those on a matter of public concern, as we have here, they were insulated from a threat of liability. The trial court's decision below challenges this kind of fundamental principle of journalism and of First Amendment jurisprudence. Now, the case here today is in an unusual posture, at least for me. This is here not on a direct appeal after a summary judgment decision in a trial, but rather on a permissive appeal under Rule 12. This is after the trial court's denial of our comprehensive motion for summary judgment. This court has taken up 4 separate issues on this permissive appeal. The first one being whether or not Mr. Verity, as a public school teacher and coach, is a public official under defamation law, which would require him to show actual malice against each of the defendants for their publications. Second is whether Idaho, in fact, recognizes this tort referred to as defamation by implication. Third, if Idaho does recognize such a tort, what those elements are. And fourth, related, is if, in fact, Idaho does recognize that tort, what are the standards of proof that are required to assert that claim in the circumstances? And I'll try to go through each of those questions in turn. First, whether or not Mr. Verity is a public official. We contend to this court that under the egregious facts of this case, which are undisputed, that Mr. Verity is in fact a public official. We are not here to argue that all public school teachers or all coaches that coach kids in high school are always public officials, but rather under the specific facts of this case, under the admitted and undisputed facts of this case, that Mr. Verity breached the fundamental trust that we put in teachers and coaches of our children. And because the publications all relate to that conduct, a matter of public concern, in this instance, he should be held to be a public official. Where do we
automatically turn every case that's a matter of public concern into the subject becoming a public figure?
I don't believe so, Your Honor. I mean, it's a good point, but I think in this specific case, because we have Mr. Verity and the facts related to him being not just a matter of public concern, but rather what did he do in his capacity as a teacher and coach. It's those duties as a governmental employee that is given that level of trust with our students, not only in the classroom, but really in this case, outside the classroom. Both, as in this case, and the court I'm sure has reviewed the record, Mr. Verity had an inappropriate physical relationship with his 18-year-old high school student that he had coached in basketball beginning in his freshman year. Mr. Verity has admitted to this conduct, which included thousands of text messages, hundreds of hours of telephone calls, and inappropriate, quote, inappropriate physical relationship involving sexual contact as defined by Oregon law. I don't mean to be graphic, but I think the facts of this case merit me telling you exactly what we're talking about. Mr. Verity engaged with sexual conduct with 18-year-old Rachel Conley. That contact.
I understand the facts of the case, ma'am, but the other issue is by the media framing an issue as public concern, they therefore frame any person as a public official. Public concern for mechanics ripping off and for millions of dollars throughout the nation, ripping off for unwanted repairs or unneeded repairs. If you do that is a public concern, millions of dollars. If you do a newspaper article on that, is my repairman then a public official?
No.
Why? Because he hasn't committed a sexual act?
No.
That's the linchpin?
For a public official, we're talking about government employees or those given such authority that that we as members of the public have a special interest in knowing about how they perform those duties. As a mechanic, you don't get to that.
Change it to the custodian who pads his records in the Capitol building.
I think you.
That's a public concern and therefore a public official?
I don't believe that case, but what you're highlighting, Your Honor, is exactly the point that each case depends on the facts presented. That each case requires this court to look at who the individual is involved, what are the responsibilities that they have been given, and what is their interest in understanding how they've carried out those duties. That is exactly the point that I think your question highlights.
So what, can you give us an example of where a teacher wouldn't fall under, wouldn't become a public figure?
Sure. For instance, if there's a public school teacher who has a dispute with one of their neighbors, and it gets in the news, obviously, just because they're a public teacher, it has no bearing whatsoever on whether or not they're also a public official for that case. In this instance, let's contrast it here. Here, Mr. Verity wasn't just a public school teacher who, had an interaction with somebody on the street unrelated to anything he did as a teacher and as a coach. The actual matter of public concern is how he carried out his responsibilities as a teacher and as a coach that had access, almost unfettered access, to Ms. Conley at all hours of the day and night because of his role as a teacher and a coach.
But basically then if the issue pertains to the teacher's role as a teacher, then basically we would be creating a rule that in that instance, the teacher would in fact be a public official.
I would submit,
public figure.
Sure, Your Honor, I would submit to you that anytime a teacher has an inappropriate sexual relationship with a student, that would elevate them to a public official status. But merely because a public school teacher is a public school teacher, the courts have never held as a matter of bright line law that all public school teachers are public officials. The closest we've come, the Supreme Court has never definitively ruled on this issue. What they did is they gave us a test in the Lorraine Journal versus Milkovich case. They gave us a test that the court can look at, in the Rosenblatt case, excuse me, I misspoke, about what we look at for what constitutes a public official. And in that case, they said you look at such thing as the people in those positions that have such apparent importance that the public has an independent interest in the qualifications and performance of the person who holds it. And like I said, while the U.S. Supreme Court has not ruled on this issue, we have at least one justice of the Supreme Court, Justice Brennan, who in his dissent made a vehement case for why public school teachers fall squarely within the definition of public officials in Rosenblatt. And we urge the court to look at that reasoning and not only apply that, but in this case, the facts are much more egregious and support a finding that in this case, under these admitted, stipulated facts, that Mr. Verity should be held to be a public official. Now, other courts have followed that. Other state courts have followed it. I think we've cited that in our briefing, including the Johnson versus Corinthian TV case out of Oklahoma, as well as some other cases. And I think there is plenty of precedent for this court to come to the same reasoning based on the specific facts of this case to rule that Mr. Verity is a public official.
But isn't the implication that Justice Brennan's vehement dissent didn't carry the day, suggestive that the public school teacher is not a public official for purposes of defamation?
Well, that was also in 1985. I think he was vehement in that, in the fact that that case wasn't squarely deciding that issue, that he was articulating his opinion, as many people do, in their dissents for another day. And the fact that state courts have picked up on that. That wasn't just a dissent and then left alone. People have looked at that, found that reasoning to be sound based on the facts as presented of their case, and followed that. So while the court did not decide that, I don't think it was dispositive of how the court may decide that if presented, particularly with facts as egregious as those presented to this court here today.
And it's a question of first impression for us?
Yes, Your Honor. It's my contention that all the issues that we're going to be talking about, we get the fun task of talking about it for the first time and discussing all the different permutations of it. It's kind of what a constitutional lawyer lives for. This is the kind of case. It's meaty. And if you have any other questions, I'll be happy to answer that. But I really want to move on to the more meaty aspect of this appeal here today, and that is whether or not Idaho recognizes this claim that's been referred to as defamation by implication.
Isn't that just another way of saying innuendo?
It's another way of saying a lot of things without saying it. I mean, that's the point of defamation by implication. If you haven't studied First Amendment law in a long time, I bet you remember going to law school, and what did you learn about defamation? Truth is an absolute defense. That's what fundamentally free speech is. I can speak truthfully about matters without being worried about being sued for them or being held responsible. That's in both the Idaho Constitution, that's in our federal Constitution, and that is in a long line of cases from this court that have consistently held that you cannot have a defamation case if you have truth. And the standard for truth isn't absolute truth. This court has articulated a number of cases that says as long as you substantially get it right, the substantial truth, the gist of the allegation is true, we're not going to hold you to absolute accuracy. But that is the standard that this court has articulated for many, many years. And that is the standard that Idaho journalists have used in reporting every single day. That is a clear line. We're going to work our hardest to get it true, to get it accurate, and we're going to publish it. I don't believe this court has yet to recognize defamation by implication. There has been argument that the court did. And the argument is that in the case of Weimer versus Ranking, a 1990 case, that this court somehow adopted that, but in doing so, never articulated that directly, didn't state any elements associated with bringing such a claim or the standards, any of the things that I'm here today to ask this court help us devise.
I appreciate that, but the single statement that the court found that there was a genuine issue of material fact as to was the statement that the evidence was overwhelming. That statement in and of itself is not defamatory. It requires that further inference or implication or innuendo for the cause of action. Why would this court have sent it back if we didn't recognize the tort of defamation by implication? I submit to Your Honor that it is a hard case to read and understand what was meant or what wasn't meant by that decision. And I submit to you, Your Honor, that if this court intended to adopt an entirely new tort, one that said you get everything right, but things that you didn't say could be held accountable to you, it would have stated that. In that case, you're absolutely right. That court held that that there was a genuine issue of material fact as to the reporter's statement that the, quote, evidence was overwhelming. That case is confusing because there's lots of talk about whether or not that's an opinion, right? Is that someone's opinion that the evidence was overwhelming, or is that a factual statement? What inferences can be drawn? And that's why that case is very confusing to people like me who are trying to give guidance to reporters about what's appropriate and what's not appropriate. But what we have is the language of the court, and only the language of the court in that case, that says there was a genuine issue of material fact as to whether the evidence was overwhelming, for which we will send it back. It was on an appeal after a summary judgment.
Well, as I read it, wasn't it the issue whether that statement was true or false?
Yeah, I mean,
That was the heart of it. Was it a false statement?
Exactly.
To say that it was overwhelming, so.
yeah, they rejected the argument that it was an opinion and said, let's look at the falsity, and that falsity of that statement, not an inference, but that statement. And that was what it was sent back to.
But is there anything defamatory about the statement? The evidence was overwhelming.
In the context of that, I think of that article, because remember, that's the context where a wife had shot herself, and the husband claimed that in the context of that article, the statement that the evidence was overwhelming was false. Because he didn't.
How did it support his defamation action unless it required?
Well, that's why I totally agree with you, Justice Horton. I totally agree with you that that decision is a conundrum. And that's why we're arguing about it, because there's not a clear articulated theory in that case, let alone setting forth, here's the test, here are the things that we're going to look at in assessing that. And I think it is significant in another reason that this court has never cited Weimer for the proposition that it recognizes defamation by implication. The court has cited that case for a number of things, primarily the actual malice rule, what actual malice means in defamation, and also for the opinion rule, what are the boundaries of opinion testimony. And it has repeatedly used that case for those two propositions. It has never cited that case since it was decided in 1990 for the proposition that Idaho recognizes defamation by implication. And we don't believe, Your Honors, that the court should take the invitation to adopt that claim in this case, particularly under the facts of this case, that this court should act with judicial restraint and say there is no need, based on the facts of this case, to go there, to adopt a claim that many courts have called a slippery slope, that is fraught with subtle complexities and constitutionally is perilous because of the different types of standards that are applied. Remember, defamation is not what was said. It's bringing an action based on what was not said that can be implied instead. So who's implying it? What are the standards? What's reasonable? What evidence to be used? Those are serious, important questions, and ones that the media needs help with, because no one that I represent and none of the amicus that are before this court seek to do anything but get at the truth, particularly on matters of public concern. That's what we're trying to do. And so far, the rules have been, if you've gotten it true, particularly on matters of public concern, you're going to be okay. It's in the public interest to disclose this information that's true and obviously a matter of public concern. So we believe that we do need a bright line rule for everyone to follow, to know what the boundaries are here, and that under well-established law of this court, if it's true or substantially true, we should be able to rely on our reporting and not be subject to liability. That the opinion privilege is still recognized by this court, that the fair report privilege, all these different axioms, I feel like it's almost like a bar review exam on First Amendment, because all these things come into play in this case, that those are all well-articulated, discussed, analyzed theories that apply here.
In this day and age of social media and the silliness that goes on in it, do normal citizens need more protection from defamation rules?
I believe, Your Honor, that it is a little crazy out there in the world.
A little?
Yeah, it can be.
You ought to see what they say about me.
But I truly believe that the jurisprudence of this country and of this state will protect individuals and give us the breathing space that the First Amendment in our own Constitution allows for the free speech. A lot of the social media stuff isn't what we're talking about here. It's a private concern, right? It may be awful, it may be all those things, but under our accepted jurisprudence, there's a much lower standard, right, when you're applying private concern issues. Yeah, That's not before this court, and I'm suggesting to you, Your Honor, and to this entire court, that the facts as presented to this court do not, there's no remedy that you need to adjust that is not already in our well-established law. The court need not go out into this new area, the Wild West of defamation law, and accept a new theory on defamation by implication. Let me turn finally to the last issue that I want to do. If this court is inclined to somehow now go beyond what it has done before, and in my opinion, what it's done before, and to accept that we're going to recognize liability on matters of public concern for things that were not said but were implied, it must do it only in very narrow, cabined, articulated way. And we suggest to you that the courts that have adopted this particular theory, and not all courts have, we fully submit that there is a split. Some courts have adopted this tort, other courts have refused to do it, saying that defamation law protects people and there's a right balance here. But if this court is inclined to go ahead and adopt that theory, we suggest that the test that has been articulated in the White versus Fraternal Order of Police test by the DC Circuit back in 1990 has been followed by many, many courts and developed over time, including the Dodds Court out of the Ninth Circuit. And we suggest to you that that is the test that this court should adopt if it is inclined to do so. And as we say, if you look at the reply brief at page 21, we try to put in words what we think the test says under Whites and Dodds and its progeny to give you a sense. I'm very visual, so I wanted to lay it out and show you what the test is under that. And it's really two different prongs. And under the first prong, it's an objective threshold determination that is to be made by the court by looking at the face of the document, the face of the document. And under that objective prong, the question is the implied defamatory meaning alleged by the plaintiff objectively reasonable from the face of the complaint? It's not, can someone somewhere come up with an inference or an implication that might be defamatory? That's not the standard. That's the wishy-washy. It's kind of like, isn't it possible? Well, everything's possible theoretically. That's not the case. It is the implied defamatory meaning alleged by the plaintiff objectively reasonable from the face of the publication? And then importantly, this is all for the court to determine, if so, if from looking at the face of the complaint, face of that document, it's objectively reasonable, does the publication itself suggest that the defendant affirmatively intended or endorsed the defamatory meaning? And that means that the defendant did something more than just reporting the true facts. And I think the hypothetical, if you had a chance to look at the district court's decision in White, they give the hypothetical that really highlights this. If a reporter says Deb Kristensen was arrested and charged with a crime, a reasonable inference from that true report is that I'm guilty of that crime. But that's not what the article said. And it would be improper, if that's all that was said, to impose liability on the writer who truthfully reported that. And that was articulated by the district court in White in footnote 12. And it really highlights the problem with these kind of cases. Now, the second prong of the White test is a fact-based determination. And that's saying, okay, we've looked at the article itself, and we've made the determination that there was an implied defamatory meaning that was reasonable, and they did something more than just state the false facts. They used inflammatory language or hyperbole to give this inference. They did something beyond reporting merely true facts to do that. Now the inquiry on the second phase is there evidence that the defendant was in fact aware of the implied defamatory meaning that's alleged and intended it? Courts have found that, so you can't just be this hypothetical, somebody in the world might come up with an implied defamatory meaning. It has to be reasonable, and then there's got to be evidence that we meant to do it.
So is that an actual malice standard?
It hasn't been articulated as actual malice. Actual malice, as you know, Your Honor, is, I know something is false, and I go ahead and say it anyway, or that's it. So it may be related, but it's not actual malice. I'm not here to argue that that equates to actual malice at all. And the courts have not articulated it as an actual malice standard, but rather there's got to be some evidence. It can't just be that you're reading this and you think it means one thing if there's no evidence that I ever intended it to be anything but what I actually stated, which was true.
But then if you couple that with the clear and convincing evidence standard.
For a public official.
And as such, I don't see much difference with actual malice.
Well, there may be very close. I believe that you get to the clear and convincing standard if you have a public official. And that's where we're getting into all the different elements, and I don't want to misstate it. But if you have a public official, you're going to be having to show actual malice no matter what. So whether it's at this element or the other. But I'm not sure about the clear and convincing part otherwise. That one, that's why you guys are on the court. You can be the standard. Yeah. Which was also my case. That was the case against the executive director of the Housing Authority. And as the court knows, in that case, the district court judge, Judge Sickle, sitting by designation, said, Idaho hasn't recognized it, but if it did, we still find that there's no case here. And he held much consistent with the White and the Dodds test that I've just articulated for you, the same thing. In that case, clearly that was a public official. She was a elected housing, or no, she was an appointed housing director in that case. So there's similarities, but I think it just shows you that if you're gonna hold someone responsible for something they didn't say, you're gonna have to meet a hard burden. I mean, that's what free speech is all about. You can't, there's gotta be something that shows, I said this, but what I really meant was something else. There's gotta be some evidence out there. And there's just not, Your Honors, that we'd submit in this case. Very quickly, the trial court, I want to make sure I highlight for you, did not find that we got anything wrong. If you look at her decision, she didn't say you got something wrong as a matter of law. Instead, she said the claim should be reframed as a defamation by implication because according to the trial court, she found that there could be 3 defamatory implications from the true facts stated. 1, that Mr. Verity was a danger to female students. And my time is short, but I will, into that case, she said.
Can we even get to what inferences the court, given the procedural posture of this case, isn't our responsibility just to answer the 4 questions that we've identified rather than looking at the nature of the inferences that the district court drew?
You mean, can you get to the actual substance of the thing? It's an appeal from a Rule 56 motion. It is, as I said at the beginning, this is a weird posture for me to be in because it's this permissive appeal, but I would submit to you, Your Honor, that the case is before you. The discovery was closed. It was fully argued to the case under Rule 56 motion. All that's left is to go to trial with hopefully some guidance or to have it not go away. It is before you. It would either it is going to be decided by you now or later, but the entire case and the facts are before you, and we submit to you that it would be helpful for all parties and a good use of judicial resources for you to decide the substantive issues. They are before you at this moment. Does the record support, again, it's up on a 56, so I'm not sure the standard of review. I've really struggled with what is this court on a permissive appeal, but it's from a Rule 56. Are you to look back at that and say, was it right granted? I would submit to you that the best course would be to decide the issues that are before you substantively on each of the 3 different things. We're fundamentally, what's the law? And then you have the entire record before you to decide whether or not it was satisfied in this case. And I will reserve the rest of my time if that's appropriate and address the rest there.
Thank you. On behalf of the respondent.
Counsel, Justices, Chief Justice, may it please the court. Justices, if this is not a defamation case, then I don't know what is. In listening to counsel's argument, she pointed out many good constitutional arguments that are obviously important. But she never mentioned once the importance of protecting one's independent right to protect their reputation. That's what I'm here to advocate for. Mr. Verity, a husband, father, teacher, and coach, fell prey to a young Washington, D.C. journalist's quest to receive a Pulitzer Prize. Mr. Riley sought out to do a story about what he perceived to be a problem of teachers losing their licenses in one state for misconduct and then getting licensed in another state. Early on in that investigation or process, he identified Mr. Verity as a teacher who had lost his license in Oregon and was now teaching in Idaho. Mr. Riley invested a lot of time and resources in investigating Mr. Verity, but unfortunately, near the end of that investigation, he learned that Mr. Verity did not fit the gist of his storyline. This was learned late in the investigation. Mr. Riley invested much time and money and effort into this story and came to the conclusion the story must go on. So he added or included Mr. Verity in his story as well, as the other defendants did. Mr. Riley, again, as the record's clear, Mr. Riley shared this information with the other media defendants, and they too published variations of the same false information about Mr. Verity. The media contends that there was nothing false about Mr. Verity in these publications, so I want to address the falsity issue first. And I'll focus, given the restrictions on time, I cannot address each and every issue specifically with each and every publication. There's at least 4.
By this argument, are you agreeing essentially with the appellants that we ought to be ultimately deciding this case? And the reason I ask that is we've agreed essentially to answer 4 questions. And the argument you're advancing seems to go to the merits. Should we do that?
Honestly, Judge, I don't think that's the case. I'm really addressing it because it was raised in their briefing, and I don't think that, and I think what you're getting at is the posture, the procedural posture we're here before. This was a question on interlocutory appeal, very specific questions, one of which was there sufficient evidence in the record? I don't believe that wasn't one of the issues raised in the request for a permissive appeal as to whether or not there was sufficient evidence upon which a jury could find, the standard Rule 56 standard. And so whether or not this article is true or false, obviously we have our position. Whether or not this court has to decide that is a question that isn't clear to me, but it is in the briefing, and I just don't want to leave it undiscussed in light of the fact that it was briefed so heavily. And it's been said multiple times, and I certainly disagree with it in the briefing, that it's undisputed that this article was 100% factual. The Misi brief made that statement many, many times. The appellants made that argument, and it's simply not true in terms of what this article said. This is clearly a case regarding defamation by implication, but there's also false statements, expressed false statements that maybe in a vacuum would not be defamatory, but again, if you read the entire article in conjunction with the false statements that were expressly made, it becomes a defamatory, very defamatory article or articles, publications.
But Mr. Shepard, isn't the gist or the sting of an article what we look to, and wasn't it essentially true as far as Mr. Verity having lost his license for inappropriate behavior? I think you described it as reprehensible in your letter to the Board of Education. And isn't the gist and the sting really about the inappropriate behavior and the fact that Mr. Verity lost his license in Oregon and then came to Idaho and got his license back, and the implication was he shouldn't have?
Your Honor, no, I disagree with that respectfully. That's not the gist of this article. The gist of this article, these articles, and I'll just say article, but we're talking about, they're all effectively the same. I think the gist of all of them are the same. The gist of this article is that he fled Oregon and moved to Idaho. He went undetected. These are words that are used in these articles in various ways. That he was a troubled and dangerous teacher, that children were not safe in his classroom. This is the gist of the article. And probably the most damaging portion of the article, in my opinion, is the fact that it made it sound like he basically up and left Oregon, disappeared and showed up in Idaho without any detection, undetected, and going through virtually no process, when in fact he went through an extensive process. As a fact, he was denied a license in Idaho, as the record makes clear. And he exercised his right to appeal that decision and went through a very rigorous process where, and it's never been alleged and it's undisputed, that he disclosed everything that happened in Oregon in that process. He went to a full hearing with a panel of 3 on the Board of Education. I forgot the name of the Professional Standards Board, I think it's called. And that process is the process where it was determined that he is fit to be a teacher in Idaho. And as a matter of fact, through that process, after a full hearing where he had his say and the state had their say, it was an adversarial process, the state decided that he was a fit and a good teacher. And they were exactly right. And the problem with this article and the effect of it is that it makes it sound like he slid under the radar screen and then he's back in the classroom and nobody knew that. And that's what was so damaging to him, because as soon as the first article came out, the phone calls came ringing off the hook about why is this guy in the classroom, and that's why he ultimately lost his job. And now he's been blacklisted from coaching his kids in baseball, all because this article suggests that he is a predator. I think that's a fair assessment or a statement. It's simply not accurate, and the fact is Idaho made a decision to give him a license based upon all the information, and they disregarded that and defamed him. And it was unfair and obviously hurt his reputation, which is what a defamation action is all about. I want to, unless you have other questions, I'll proceed. I hit already a little bit about what Justice Horton, about the issue of whether or not it was true and whether or not we need to talk about that. Your question, I asked it a little bit, so I'm going to move on then. I think it's safe to say, and that the record's clear, that there's many express statements in these allegations, in these articles, as well as implications that suggest many false things about Mr. Verity. Again, he didn't flee Oregon. It was about a 4-year time frame from the time this conduct occurred before he decided to go to Idaho. He stayed in Oregon. He faced the music in Oregon and attempted to get his license back. And at some point, him and his wife decided to move back to Idaho, where they were from, by the way. They didn't go to some far-off land when you flee, where they have extended family, and they wanted to get back here anyway. So the notion that they fled a troubled past is simply not a fair way to describe what he did, and it's frankly defamatory. With regard to the common law, and again, counsel wanted to focus on the Constitution, which is obviously very important, but there's a countervailing issue here, of course, which is one's reputation, the right to protect that. And so I just want to briefly talk about how I see the law and the analysis in that regard. It's the starting point for the analysis in my mind is that the common law clearly provided a remedy for defamation, and I think it's also very clear that that included defamation by implication.
When did English common law first recognize the tort of defamation by implication or innuendo?
When did it first do that?
Because I'll be honest, this court's bounced around whether we looked at what the state of the common law was in 1864 at the time of the territorial adoption of the predecessor to 73-116, or the time of statehood when Article 22, Section 1 said that basically all laws not in conflict come into play. We look at either 1890, July 3rd, or 1864, but in either event, we looked at the state of the English common law at that point, and so that's the reason for my question.
Well, I wish I had the answer to that, and I do not, Your Honor. I read the treatises that were briefed in this case, and that's as far as I got in that to answer that question. I can't answer that. It's a good question, and I wish I could answer it, but I don't know the answer to that.
Yeah, because
but
I looked at the only reference in your brief was the Rapp decision, which in turn referenced a scholarly article by Brandeis and Warren. I went into that article. It cited one 1845 case, but had nothing to do with English common law. And So your argument hinging on 73-116 seems to be very much contingent on that question.
Fair enough, Your Honor, and I just can't answer that for you. But at any rate, as I understand it at least, the common law did recognize defamation by implication. I don't know that they necessarily called it that, but, and again, well, I'll get to that in a minute, but so the history of common law, or the history of defamation rather, starts with the idea that defamation is actionable. And of course Idaho, as I think you just pointed out, has adopted specifically, expressly the common law to the extent it's not repugnant to the United States Constitution. Of course, the common law was modified by the New York Times standard, the malice standard regarding public officials. In 1967, the Supreme Court in the Curtis Publishing Company case made that applied to public figures. But then the court was asked in 1974, the U.S. Supreme Court that is, whether or not this malice standard was going to apply to private individuals. This is the Gertz case. And they answered that in the negative. In the Gertz case, they recognized that there's two issues, two countervailing issues, that, and both are equally important: the constitutional First Amendment, the Constitution, and one's right to protect their individual, their reputation. And in the Gertz state case, they made it clear that the states may define for themselves the appropriate standard of liability for publishers of defamatory statements regarding private individuals. And the court recognized that individuals that aren't public officials are uniquely vulnerable to private or to defamation and aren't in a position to protect themselves like a public official. And so based upon that, private individuals are treated differently. And then finally, we've got the rubric of public concern, which everybody agrees, both parties agree that the issues before this court and Mr. Verity do certainly fit within that rubric. This is certainly a matter of public concern by the virtue of the fact that Mr. Verity is a public school teacher and works with children. But I certainly disagree with the idea that Verity or any public school teacher, just by virtue of being a public school teacher, is a public official.
How do we deal with the footnote 3 in Hemingway then, where we cited with approval Prosser's statement that various minor officials like high school principals, police lieutenants, are public officials? How do we...
What case was that, Your Honor?
Hemingway versus Fritz, where we cited with approval Prosser for a list of various minor officials such as high school principals, police lieutenants that have been held to be public officials. We believe they illustrate the type of public officials who must be willing to accept exaggerated, crude, or tactless criticism in relation to their public duties.
Well, I guess my answer to that is, first and foremost, the question is how do you deal with that? I think the answer is you need to analyze it based upon I don't think that's binding authority, if that's the first question. If it's in a footnote, I would argue it's not. I wish, again, I apologize, I'm not familiar with that footnote, I guess I missed it. But if it's a case of this court and it's a footnote, it sounds to me like it's not binding authority. It may be something, obviously you want to make note of it, but I think the Supreme Court, the U.S. Supreme Court, who is the final arbiter of the constitutional issue, U.S. constitutional issues, have set out the tests for determining public official. And public...
It's fair to say, though, that that's minimum levels of protection, that this court is free to extend greater protections to media defendants, are we not?
I don't understand your question. You want to say it again, please?
Isn't this court free to set elevated standards of protection for media defendants beyond those that the Supreme Court has?
Yes, absolutely correct. Yes, that is right. This court is not, yes. This court can set, and that's what my previous argument was, this court can set, the Supreme Court sets the floor. You guys can, this court can protect the media beyond that, and frankly, this court can protect individuals and the right to
That's the tension. Do we look out for the rights of the interests
Yes.
of the individual or those of the media?
And of course, I submit that, well, and this is a good opportunity to take a point that I thought a lot about throughout this process. The media is extremely important. It was so important that it was put in the First Amendment. But the reality is, the media is really a means to an ultimate end, which is to protect individuals from oppression. So even though the First Amendment talks in terms of, and the media relies on the First Amendment, I think it's important to keep in mind, without individuals, the media is really pointless. It's designed to protect individuals from the masses and oppression and that kind of thing. So it's kind of just in the back of my mind that, look, the media is not a means to an end. I mean, an end of itself. It's there to protect we the people. But having said that, going back to Mr. Verity as a public official, school teachers aren't in a position to combat defamatory statements as compared to their counterparts that are public officials. They are more vulnerable to injury by defamatory statements, and the state's interest in protecting that is correspondingly greater. That was the Gertz case. I think that clearly describes public school teachers. Public school teachers do not have any substantial responsibility or control over conduct of government affairs. That's another factor that has been looked at in the public official discussion. They do not govern the public school systems or make local education policy, and they're not elected officials. The states are clearly split on the issue with regard to this, but I think the better policy, and I ask this, and I think this court should adopt the position that public school teachers are not public figures. They deserve the same protections as any other private individual. And to create, and then because if we don't adopt a rule like that, first of all, I think it could have a chilling effect on hiring teachers. I mean, if they know they're exposed to a higher level of defamation, I guess, for lack of a better way to describe it, then the average citizen, they may not want to take up the job of public school teachers. The other problem with creating this, making public school teachers public officials, is it creates what I would consider unfairness when you compare them to, does that mean our private school teachers are going to be treated differently than public school teachers for defamation analysis? That's another problem with this idea, and certainly that would create a problem for the public school system recruiting teachers if they know that if they go get, first of all, they may get paid better. That's a common knowledge, but beside that, they now have more exposure to being criticized in an unfair way. And so I think for various reasons, the clear best public policy is to err on the side of caution, protect our public school teachers, and not make them subject to the kind of scrutiny that other public officials are subject to. I'll next change my discussion to the defamation by implication. I respectfully disagree with counsel that it doesn't exist in Idaho. It hasn't been called that per se, but I think I don't know how you can get around and I may be pronouncing the name wrong, Weimer v. Rankin case, and come to the conclusion that defamation by implication doesn't exist. That case has been discussed a little bit already, involved it was a criticism. The article that was at issue in that case was a critical article about an investigation done about what was ultimately determined a suicide. And the plaintiff in that case was never mentioned in the article by name. The article never said any specific facts about that plaintiff, but as it's been pointed out, there was a statement that the evidence was overwhelming. And from that statement, the court concluded that a reasonable jury could conclude that the implication from that statement, and in the context of that article, is that the plaintiff lied during the investigation, which was defamatory, the court found, and that he committed homicide, which of course is defamatory. Defamation by implication exists, not only in common law, which has been adopted by the state, but by virtue of that case. I also think, Your Honors, that the U.S. Supreme Court has recognized defamation by implication, and again, maybe not in so many terms. I would cite the court to Milkovich v. Lorraine, and there's a couple of Milkovich v. Lorraine cases out there, so this is the 497 U.S. 1 case. And I just, if the court will indulge me real quickly, read a quick passage from that case, because I think it's really telling. It says, if a speaker says, in my opinion, John Jones is a liar, he implies a knowledge of facts which lead to the conclusion that Jones told an untruth. Even if the speaker states the facts upon which he bases his opinion, if those facts are either incorrect or incomplete, or if his assessment of them is erroneous, the statement may still imply a false assertion of fact. Simply couching such statements in terms of opinion does not dispel these implications, and the statement, in my opinion, Jones is a liar, can cause as much damage to reputation as the statement, Jones is a liar. As Judge Friendly aptly stated, it would be destructive of the law of libel if a writer could escape liability for accusations of defamatory conduct simply by using explicitly or implicitly the word I think. Now, that case, as the court may know, was involved in opinion, and whether or not opinion was absolutely privileged or if it can be actionable. And that court decided that opinions, in fact, could be actionable, used in the right context, or in the wrong context, I should say, if it implies a defamatory statement. I don't see any principal distinction between that and a case where statements are used and placed just perfectly in a context, although the statements are literally true, if they have a defamatory meaning. I used a couple of the hypotheticals in my briefing. The one that John killed John, and that was Joe killed John. That's clearly a defamatory statement in isolation. But if it's put in an article regarding a wrestling match between the two, and it's clear they're talking about that Joe defeated John, it would not be defamatory. I also talked about the Mary article, plugging Mary into an article about infidelity, and how that could be a true fact could clearly be have defamatory implications. I want to use one, and because counsel did not like my Mary hypothetical in light of their reply brief, I wanted to use one real world example of how easily it is to intentionally mislead using very truthful statements. The court is well aware that Judge Kavanaugh is going through the confirmation hearings in front of the Senate right now. And during that process, he was asked by one of the members of the committee about a case that he was handling. And his answer, he articulated the position of that litigant, not his position, but the litigant. And that position was that birth control pills are abortion-inducing drugs. He was stating the litigant's position. Well, a well-known prominent opposition of Kavanaugh sent out a tweet, and I quote, "I want to be sure we're all clear about something that Brett Kavanaugh said in his confirmation hearing last week. He referred to birth control pills as abortion-inducing drugs. That set off a lot of alarms for me, and it should for you too." I heard that, and I saw that tweet, and I thought, man, that's exactly what we're talking about in a couple of weeks in front of the Supreme Court. Nothing about that tweet is literally false. Brett Kavanaugh absolutely said that, and she put it in quotes, or this person put it in quotes, abortion-inducing drugs, and he did refer to abortion pills, birth control pills that way. But of course, the purpose of the tweet was to make it sound like it was his position, and it clearly was not the case. And so it's a perfect example, in my mind it was at least, of how easily it is when the intent is to mislead, to use a factual statement and mislead someone so egregiously. This is why defamation by implication should be recognized in Idaho. And frankly, in my opinion, it already is in light of the cases I've already cited. I'm about out of time. I want to conclude with the following. And again, sometimes I can articulate better by just quoting some good information from a wise justices. So I want to quote quickly from Justice Stewart in his concurring opinion in Rosenblatt. He says, quote, "The right of man to protection of his own reputation from unjustified invasion and wrongful hurt reflects no more than our basic concept of the essential dignity and worth of every human being. a concept at the root of any decent system of orderly liberty. The destruction that defamatory falsehood can bring is, to be sure, often beyond the capacity of the law to redeem. Yet imperfect though it is, an action for defamation is the only hope for vindication or redress the law gives to a man whose reputation has been falsely dishonored. In conclusion, I want to say that the publications at issue disseminated about Mr. Verity cost him his job, his livelihood, his ability to coach his kids. He can get the money back from the lost job, but he'll never get back the time with his kids and coaching his kids. This is an egregious case of defamation, and this court should affirm the district court in total. Thank you.
Thank you. How much time does the appellate have?
Thank you, and I'll try to use my 2 minutes very wisely. Justice Stegner, you were asking me about Justice Brennan's dissent in the case, and I just went back and I wanted to just point out that that was a denial of cert. That wasn't a substantive ruling on the merits of the case in that case, so that's why I remembered it as being not a dispositive motion. So just one point of clarification there. I want the court, if the court is going to be looking at what Mr. Shepard has invited to do, the truth or not truth or how accurate or it isn't, I want the court to write down just a few record sites that will give you a sense of why everything we said was right. Record at 413 is the Caldwell School application that Mr. Verity completed. In response to why did you leave the Crook County School District, his exact response was, resigned from teaching position, contractor opportunity. He said that throughout his applications to the Idaho officials. That's at record 413. Record at 436 was the Valley View application. And in the Valley View application, specifically in response to the question, has any disciplinary action been taken against you for misconduct? Mr. Verity responded, no. This is not a record that says that he was forthcoming with his past. I'll submit that to you. What we have reported is true. And Your Honors, I submit to you that under the Supreme Court's decision in Gertz, the Supreme Court instructed us that the court must err on the side of protecting free speech on matters of public concern. Quote, the First Amendment requires that we protect some falsehood in order to protect speech that matters. Again, the trial court below did not find that we published anything false, but rather found implications. We don't believe this case presents the kind of case that this court needs to go beyond that. And I will leave you with this. Throughout the briefing, Mr. Verity has tried to describe himself as a victim in this case, as a model teacher, as a model husband. Okay. 8, okay. Thank you, Your Honors. I appreciate your time.
Matter is now under advisement. We'll render decision.
Thank you.
Welcome to Idaho in Session. Idaho in Session is sponsored by the Idaho State Broadcasters Association, Idaho Realtors, the Association of Idaho Cities, Boise State University's Idaho Policy